Hello everybody, welcome to Daily News Simplified, an answer to what, why and how of newspaper reading. Today we shall be analyzing the Hindu newspaper dated 6th of April 2019 of the New Delhi edition. The topics to be discussed today has been presented on your screen. Timestamping for the same has been provided in the description box below. Let us begin our today's discussion. Now the first article appears on page number 6. The title of the article is Privacy in the Age of Sunshine Laws. This article shall be important mainly from the perspective of GS Paper 2, Governance, under the subsection Important Aspects of Governance as well as Transparency and Accountability. Before analyzing this particular article, let us first look into its background. Now, in the year 1997, the Supreme Court of India had passed a resolution. Now, this particular resolution required the judges to disclose their assets on an annual basis to the Chief Justice of India. Such a resolution was basically adopted in order to improve the trust and credibility of the higher judiciary. Subsequently, in the year 2007, an RTI activist by the name Subhash Chandra Agarwal filed for an RTI application before the Supreme Court. In this RTI application, Subhash Chandra Agarwal sought to know whether this particular resolution of the Supreme Court was complied with by the judges. That is to say, the RTI application sought to know whether the judges of the Supreme Court disclose their assets and liabilities to the Chief Justice of India. What is important to be noted here is that this RTI application did not explicitly ask for the disclosure of assets and liabilities of the judges. Rather, it only sought to know whether the judges complied with the resolution. However, the Supreme Court of India rejected this RTI application on the grounds that the declaration of assets and liabilities is a personal information of the judges, and such kind of personal information is exempted under the RTI Act. More importantly, the Supreme Court stated that the disclosure of assets and liabilities under the RTI Act would violate their fundamental right to privacy. Now, this particular argument put forward by the Supreme Court would mean mainly two things. Firstly, a citizen of India cannot file an RTI application to know whether the judges have complied with the 1997 resolution. Secondly, a citizen of India cannot file an RTI application to know the assets and liabilities of the judges in India. However, this particular argument put forward by the Supreme Court was then rejected by the Central Information Commissioner. The Central Information Commissioner ruled that the RTI application only sought to know whether the judges have complied with the 1997 resolution, and this RTI application did not explicitly ask the judges to disclose their assets and liabilities to the common public. It is on this particular aspect the Chief Information Commissioner ruled that the Supreme Court is bound to inform the public to the RTI on whether the judges have complied with the 1997 resolution. Subsequently, this particular case has now been taken up by the Constitutional Bench of the Supreme Court, wherein the Constitutional Bench is deliberating as to whether an RTI application can be filed in order to know whether the judges have complied with the 1997 resolution, as well as whether an RTI application can be filed to know the assets and liabilities of the judges. It is in this particular regard, this article here highlights that the Constitutional Bench of the Supreme Court would find it difficult to give a verdict on this particular case. This is because this case essentially involves the fundamental right to privacy versus the right to information under the RTI Act. Hence, as part of this video analysis, let us understand some concerns raised in this particular article with respect to the disclosure of assets and liabilities by the judges. While rejecting the RTI application with respect to disclosure of assets and liabilities of the judges, the Supreme Court of India has taken recourse to Section 8 of the RTI Act. And as we have discussed, Section 8 of the RTI Act provides for an exemption for the disclosure of personal information by the public authorities. Now, this particular disclosure of personal information is mainly exempted on two grounds. Firstly, the disclosure of personal information should not have any kind of relationship to any public interest. The basic idea here is that the public authorities should not be forced to disclose their personal information just because they hold a public office. And secondly, the disclosure of personal information can be exempted if it leads to an unwarranted invasion of privacy. Now, if one looks at the second ground for exemption, this can lead to conflict between the right to information versus the right to privacy. Hence, in order to avoid the unwanted conflict between the right to information versus the right to privacy, one has to look at the basic philosophy of the Section 8 of the RTA Act. The Section 8 of the RTA Act basically states that the personal information of the public authorities can be withheld only when it does not serve the larger public interest. In other words, if disclosure of personal information serves the larger public interest, then the disclosure of such personal information cannot be exempted under Section 8 of the RTI Act. So, between the right to information and the right to privacy, Section 8 of the RTI Act has given higher preference to the right to information and not to the right to privacy. Similarly, in an earlier case known as PUCL versus Union of India case in the year 2013, even the Supreme Court of India had given primacy to the right to information over the right to privacy. It is to be noted that in this famous historic case, the Supreme Court of India had directed all the contesting candidates to compulsorily disclose the assets and liabilities of their spouses. And when the contesting candidates argued that such kind of disclosure may violate their right to privacy, the Supreme Court stated that the right to privacy of the individuals has to be subordinated to the right to information of the public. And this is because such kind of subordination serves a larger public interest. So if one looks at the verdict of the Supreme Court in this particular case, this clearly highlights that the Supreme Court has been trying to promote the transparency and accountability in our democratic system. Apart from this particular case, there have been a lot of instances wherein the Supreme Court of India has been trying to promote transparency and accountability in our country. Surprisingly, with respect to declaration of assets and liabilities by the judges, the Supreme Court has given a higher preference to right to privacy over the right to information, wherein the Supreme Court has been arguing that the disclosure of assets and liabilities by the judges would be an unwarranted invasion of privacy. So the main challenge before the constitutional bench here is that if this particular constitutional bench declares that the disclosure of assets and liabilities of the judges is exempted under the RTA Act, then such a ruling of the constitutional bench would essentially overrule the Supreme Court ruling in the PUCL versus Union of India case. And accordingly, such an exemption would get extended even to the political class. And this can be considered as a huge setback to the electoral reforms in order to promote the transparency and accountability of the political class. Let us now understand as to why the judges should declare their assets and liabilities under the RTI Act. It is being said that the judiciary in India is considered to be one of the most powerful judiciary across the world, wherein the Indian judiciary has been given sufficient amount of independence and autonomy by the Indian Constitution. Now the judiciary has to realize that this independence and autonomy should actually match its accountability. That is to say, the accountability and autonomy of the judiciary should go hand in hand. However, it is observed that the accountability of the judiciary is quite poor in India, wherein even though the power of the judiciary has increased by leaps and bounds, the accountability of the judiciary has continued to remain poor. For instance, in spite of allegations of gross misconduct, no judge of the Supreme Court has ever been removed. Further, the Indian judiciary presents a classic example of judges appointing themselves. However, the appointment of judges has continued to remain opaque, and there have been allegations of favoritism and nepotism with respect to the appointment of judges. Hence, it can be stated that the higher independence and autonomy enjoyed by the judiciary in India has not been matched by its accountability. Hence, the disclosure of assets and liabilities by the judges would ensure that the judiciary remains accountable to the people. Secondly, it can also be argued that the judiciary of any country should always remain above suspicion. That is to say, people should not have any kind of doubt with respect to the misconduct or corruption in the judiciary, and such disclosure of assets and liabilities would remove all kinds of doubts from the minds of people with respect to the functioning of the judiciary. Alternatively, it can also be argued that if there is nothing to hide, then why should the judges fear in declaring their assets and liabilities under the RTI Act? Thirdly, it can be argued that the disclosure of assets and liabilities by the judges would improve the transparency in the functioning of the judiciary, and this would improve the public credibility and trust with respect to the judiciary. And lastly, it can be stated that the declaration of assets and liabilities by the judges would enable them to take a moral high ground wherein the judges can act as a role model in order to improve the transparency and accountability of the government. So these are some of the important aspects which one must know with respect to this particular article. Further, based upon a video analysis, an expected UPSC mains question for your practice would be the autonomy and accountability of the judiciary in India has to go hand in hand. In this regard, discuss the need for declaration of assets and liabilities by the judges under the RTI Act. Now you can try writing answer to this particular question based upon our video discussion. With this, let us now take up the next article. Now the next article appears on page number 10. The title of the article is David Malpass named as World Bank President. This article shall be important from the perspective of GS Paper 2 International Relations under the subsection Important International Institutions. Now this particular article has highlighted that David Malpass has been appointed as the World Bank President. Hence, as part of this video analysis, let us understand as to how the President of the World Bank is appointed. In order to understand as to how the World Bank President is appointed, one would be required to understand the structure of the World Bank. When it comes to the structure of World Bank, the World Bank is mainly governed by three different organs, these being the Board of Governors, Executive Directors, and the President of the World Bank. Now coming to the Board of Governors, the Board of Governors essentially consists of the representatives of all the 189 member countries of the World Bank, wherein each of these member countries is represented by their finance minister. Now with respect to mandate of Board of Governors, the Board of Governors takes the broad policy decisions and it meets once in a year. Now coming to the Board of Executive Directors, presently it consists of 25 Executive Directors. Out of 25 Executive Directors, 5 Executive Directors are appointed by the 5 largest shareholders of the World Bank. And these 5 largest shareholders of the World Bank are the United States of America, Japan, China, Germany, and United Kingdom. So all of these 5 largest shareholders appoint one executive director, and the remaining 20 executive directors are elected by other member countries. Now with respect to mandate of executive directors, the executive directors looks after the day-to-day functioning of the World Bank. Now coming to the President of World Bank, the President of World Bank is actually selected by the Board of Executive Directors, and he or she is selected for a period of 5 years. And the main role of the President of World Bank is to chair the meeting of the Board of Executive Directors. So you can see here that the President of World Bank is selected by Board of Executive Directors consisting of 25 members. Now you all must be aware that both World Bank as well as International Monetary Fund were set up post the Bretton Woods Conference in the year 1945. It is on account of this both World Bank and IMF are also referred to as the Bretton Woods twins. Now it has been observed that because of a tacit agreement between the United States of America and the European Union countries, the World Bank is always headed by an American, whereas IMF is always headed by a person from Europe. So even this time as well, David Malpass, who is a senior US Treasury official, has been appointed as the World Bank President for a period of 5 years. Now India has been pushing for reforms to be undertaken in both World Bank as well as IMF, wherein India has been demanding for a higher voting share in these two organizations. Apart from that, India has also been demanding that the presidents of these two international institutions should be selected based upon merit and not based upon the nationality. Further, with respect to your upcoming prelims, one should also have a basic idea related to the World Bank Group. It is to be noted that the World Bank Group basically consists of five international institutions. All these five international institutions are together referred to as the World Bank Group. However, the first two international institutions, that is, the International Development Association and the International Bank for Reconstruction and Development, these two institutions are together referred to as the World Bank. So the basic difference between the World Bank Group and the World Bank here is that the World Bank Group consists of all the five international institutions, whereas the World Bank consists of only these two international institutions. Now coming to the International Development Association. Now this particular international institution provides for loans to the world's poorest countries at a nil or a lower rate of interest. The International Bank for Reconstruction and Development provides loans to the middle income as well as the credit worthy poor countries. The International Finance Corporation provides loans to the private sector in the developing countries. The Multilateral Investment and Guarantee Agency encourages investment into the developing countries by giving insurance against the political risk. And lastly, the International Center for Settlement of Investment Disputes, as the name suggests, handles disputes related to the international investment. Further, you need to note that India is a member of all these international institutions except the International Center for Settlement of Investment Disputes. So these are some of the important aspects which one must know with respect to this particular article. With this, let us now take up the next article. Now the next article appears on page number 10. The title of the article is US revokes ICC prosecutor's visa. This article shall be important from the perspective of GS paper 2 International Relations under the subsection Important International Institutions, their structure and mandate. Let us first understand as to what is the nature of conflict between US and International Criminal Court. Now recently, the chief prosecutor of the International Criminal Court had expressed her intentions to open an investigation against the alleged war crimes committed by US soldiers during its war in Afghanistan. In response, US had threatened to take tough action against the International Criminal Court. And as the article here has highlighted, US has decided to revoke the visa which was granted to the ICC prosecutor. As part of this video analysis, we shall predominantly focus on different aspects of the article. Firstly, we'll understand as to what exactly is the International Criminal Court. Secondly, the jurisdiction of International Criminal Court. Thirdly, the link between the International Criminal Court and United Nations. And lastly, what is India's viewpoint with respect to the International Criminal Court? Let us start analyzing these aspects of the article one by one. Now coming to what exactly is the International Criminal Court. Now International Criminal Court is a permanent international court which has been established in order to investigate, prosecute and try individuals who have been accused of the war crimes, genocide, crimes against humanity as well as the crimes of aggression. The International Criminal Court has the power to prosecute only the individuals and not the states. In other words, the International Criminal Court can prosecute only the individuals who have been accused of these crimes. However, if such crimes are committed by the countries, then the International Criminal Court would have no powers as such. Further, you need to note that the International Criminal Court has been set up under the Rome Statute. Now coming to the jurisdiction of International Criminal Court, it is to be noted that the jurisdiction of International Criminal Court extends to only those countries which are members to the Rome Statute. Now what is important to be noted here is that if the International Criminal Court wants to take up a case for investigation, then it has to fulfill two major criteria. The first criteria here is that these crimes should be committed by a person who is a citizen of a member country. And the second criteria here is that the International Criminal Court can also take up a case for investigation even when a crime is committed in a member country. However, such a crime may not have been committed by the citizen of that particular country. Now let us understand this by a simple example. Let's say country A is a member of International Criminal Court. Now the ICC can take up a case for investigation under two different criteria. Firstly, if the offence is created by the citizen of the country A, and secondly, when the offence is committed in country A. Now with respect to second criteria, such an offence may have been committed by a person of a country which is not a member of the International Criminal Court. Even in such cases as well, the International Criminal Court can take up a case for investigation. Now, with respect to the recent tussle between the International Criminal Court and ICC, Afghanistan is actually a member to the Rome Statute. US is not a member to the Rome Statute. However, the US soldiers have been accused of carrying out the war crimes in the territory of Afghanistan. It is on account of this particular reason the chief prosecutor of International Criminal Court wanted to start an investigation against the US soldiers for the war crimes which they had committed in Afghanistan. Now coming to the nature of link between the International Criminal Court and the United Nations. Now the Rome Statute which established the International Criminal Court was actually negotiated within the United Nations. However, the Rome Statute decided to establish the International Criminal Court as an independent judicial body outside the United Nations. Which means to say, the International Criminal Court is neither an agency or an organ of United Nations. On the other hand, the International Court of Justice is a principal judicial organ of the United Nations. In this regard, let us look at some of the important differences between the International Court of Justice as well as the International Criminal Court. Now, with respect to the jurisdiction of the International Court of Justice, its jurisdiction lies over all the United Nations member states. On the other hand, as we have discussed, the jurisdiction of International Criminal Court extends over only those countries which are member countries to the Rome Statute. Now, with respect to mandate of these international institutions, the International Court of Justice mainly settles the legal disputes involving the UN member states. Now, these legal disputes could be related to the issues of sovereignty, boundary dispute, maritime dispute, etc. So, if one looks at the mandate of International Court of Justice, it is more of a civil code. On the other hand, if one looks at the mandate of International Criminal Court, as we have discussed, it has been established to investigate and prosecute individuals who have been accused of crimes such as genocide, crimes against humanity, war crimes, crimes of aggression, etc. So looking at the mandate of International Criminal Court, this court mainly handles cases which are criminal in nature. Further, another important difference here is that the International Criminal Court can try and prosecute the individuals. However, such powers are not available to the International Court of Justice. And lastly, with respect to the linkages with the United Nations, the International Court of Justice is considered as the official court of United Nations. On the other hand, the International Criminal Court is an independent judicial body which is set up outside the ambit of the United Nations. However, what is important here is that the International Criminal Court can take up a case based upon the reference of the United Nations Security Council. Now, with respect to India's stand on the International Criminal Court, India has neither signed nor ratified the Rome Statute, which means to say India is not a member of the International Criminal Court. And the basic reason for India to remain outside the International Criminal Court here is that, firstly, India believes that the International Criminal Court is a violation of the state's sovereignty. This is because the Indian government believes that all these crimes should be tried and prosecuted by the highest court of law in India, that is the Supreme Court, and no international court should exercise its jurisdiction over the Indian territory. Secondly, India has raised an apprehension that if India becomes a member of the International Criminal Court, some of the countries may use the India's membership for political motives. Now, for example, if India becomes a member of International Criminal Court, some of the other countries can drag India to the International Criminal Court on the baseless allegations of the crimes against humanity. and this can be considered as unnecessary interference in India's internal affairs. It is because of these two reasons India has not become a member of the International Criminal Court. So these are some of the important aspects which one must note with respect to this particular article. Now, based upon our discussion, a mains question for your practice could be: discuss the mandate and jurisdiction of International Criminal Court. Analyze the reasons for India's reluctance to become a member of the International Criminal Court. With this, now let us take up the next article. Now, the next article appears on page number 5. The title of the article is In Harmony. This article shall be important mainly from the perspective of prelims under the subsection Cultural History of India. Now we have picked up this particular article because normally it has been observed that in UPSC questions have been asked with respect to the various tribal communities of India, their rituals, customs as well as festivals. In this regard, this article has highlighted that the Naga tribal women are taking part in a show in order to set a Guinness World Record for the largest traditional Konyak dance. Hence, as part of this video analysis, let us understand some basic details related to the Konyak dance. The Konyak tribes are among the 16 major tribes found in the state of Nagaland. The Konyak tribes mainly live in the Mon district of Nagaland. Apart from that, they are also found in the neighboring states of Arunachal Pradesh as well as Assam. Now, these tribal people have tattoos over their faces, hands as well as legs. And with respect to the important festivals of the Konyak tribes, two important festivals of these tribal communities are the Oilang Manyu as well as Lao Ong Mo. Now, the Oilang Manyu is celebrated in the first week of April after the sowing of seeds by these tribal communities. Apart from that, this particular festival is also celebrated in order to welcome the new year. And with respect to the Lao Ong Mo, this festival is mainly a harvest festival which is celebrated in the month of August or September. So if one looks at the previous year UPSC prelims, questions are normally being asked with respect to the important festivals of the tribal communities. It is in this particular regard, these two festivals becomes extremely important with respect to your upcoming prelims. With this, let us now take up the next article. Now the next article appears on page number 18. Now this particular article highlights that a new species of spider has been found in the forest of Kerala. This article shall be important mainly from the perspective of prelims under the subsection General Issues on Environmental Ecology. Further, this article is also important because in prelims 2016, a question was asked with respect to the discovery of a new species of banana in Andaman and Nicobar Islands. It is in this particular aspect the discovery of new species of spider in the state of Kerala becomes important. Hence, as part of this video analysis, let us understand some basic details related to the new spider species. This new spider species has been discovered for the first time in the Western Ghats region, more particularly in the Ernakulam's Illitodu forest. Now, the scientists have observed that this new spider species is similar to the jumping spiders that are normally found in Eurasia as well as Africa. However, this new species found in India is considered to be quite different from those found in other regions because they have a different reproductive organs, because of which they have been considered as new spider species. And with respect to the genus classification, you need to note that they are categorized under Habrocestum longispinum. And lastly, they are predominantly brownish black in color with white and creamy yellow patches. So with respect to your upcoming prelims, please note that the new spider species has been found in the Ernakulam district of Kerala, and also make a note of the genus classification of the new spider species. With this, let us take up the next article. Now the next article appears on page number 18. The title of the article is Rise in Obesity, Vision Related Issues in the Indian School Children, says study. This article shall be important from the perspective of GS paper 2 under the subsection Issues Related to the Development and Management of Health. Recently, an organization known as Germa Wellness has released a report titled as Enhancing the Effectiveness and Impact of Schools, Insight from School Health Screening Program. Now, this particular report has highlighted that the school going children in India in the age group 2 to 17 years have been facing the problems such as obesity, vision, as well as dental related issues. Wherein the report has highlighted that the uncorrected vision is affecting almost 50% of the children in the higher and secondary schools. Apart from that, 30% of the school going children are suffering from the abnormal body mass index. Apart from that, approximately around 50% of the school going children are suffering from poor oral health. Now, these are some of the important aspects which one must know with respect to this particular article. Now, based upon a video analysis, these 4 questions shall be a prelims question for the practice. Please pause this video and try to find answers to these 4 questions. We will be discussing the answer after 5 seconds. The first question here is, which among the following international institutions together form the World Bank? The options which are given here are the International Development Association, the International Bank for Reconstruction and Development, the International Finance Corporation, Multilateral Investment and Guarantee Agency. Now, as we have discussed, both International Development Association and International Bank for Reconstruction and Development together form the World Bank. On the other hand, these 4 institutions, along with the International Center for Settlement of Investment Disputes, form the World Bank Group. So the correct answer to this particular question is A, that is 1 and 2 only. Now coming to second question, the question here is, consider the following statements related to the International Criminal Code. The first statement is, it is an international code which can investigate cases related to genocide and war crimes. As we have discussed, this statement here is correct. The second statement reads as, it can prosecute both individuals as well as the member states. Now this statement here is wrong. This is because the International Criminal Court can try and prosecute only the individuals and not the member states. The third statement reads as, it works under the United Nations. Now even this option here is wrong. So if you look at the options which are given here, the correct answer to this particular question is A, that is 1 only. Now coming to the third question, the question here is, consider the following statements related to the Right to Information Act. The first statement reads as, it provides for exemption from disclosure of personal information by the public authorities under certain circumstances. As we have discussed, this statement here is correct. The second statement reads as, it states that the judiciary would not be considered as the public authority under the Act. Now, this statement here is wrong. So the correct answer to this particular question is A, that is 1 only. Now coming to fourth question, the question here is, consider the following statements related to the World Bank and IMF. The first statement reads as, the president of World Bank has always been an European, while the president of IMF has always been an American. Now this statement here is wrong. This is because the president of World Bank has always been an American, while the president of IMF has always been an European. Now the second statement reads as, India is among the top 5 shareholders of World Bank and IMF. Now even this particular statement here is wrong. This is because India is not among the top 5 shareholders of IMF and World Bank. For instance, with respect to IMF, India presently occupies the 8th position. Similarly, with respect to India's shareholding in the World Bank, it is presently placed at 7th position. So the correct answer to this particular question is D, neither 1 nor 2. With this, we have come to end of today's discussion. Now let us look at the question for the day.